I was just looking at this penalty of perjury and the laws of the state of Washington. Yeah. That the above information is true and correct concerning myself and is accurate to the best of my knowledge as to the other party. Yeah. Now, they have a signature necessary here as the petitioner. Right. Did she sign that LEIS form, Poe? Or did the court take it upon themselves to issue these things without the petitioner's involvement? Pooch. Now there's an addendum. Oh, this is a restricted access document. Yes. My additional respondent information, right? Driver's license, identification card. Excuse me. Now, my son's names. Yes. I would like to have them. Yes. I want my sons. Do you understand? I'm going to go through every signature of every form that this county has issued since Heidi moved here from Guam on July 3rd of 2011. Now I want you to remove your fraud from my name. Do you understand? I want to know every lithium battery and all lithium prescription drugs where somebody got a prescription to lithium and thought, well, we'll just light the place up. Now, the timing light wasn't good enough for you. Ooch. So you thought you'd put a little lithium in the system? Pooh. Why don't you explain exactly how lithium, yes, and a timing light, yes, and a little electricity that runs through salt. Now, I know your thought was that you'd salt my legs, but you salt and lithium the legs. Ow, ow, ow. The court finds the court has jurisdiction over the parties. Oh, what's this called? The temporary order for protection and notice of hearing. I never got one of these, but there's a date of birth required on this? Yes. And they have 5 lines there for the 5 minors named. Yes. And then the respondents, yes. This looks similar to the protection order, but I didn't get this. Now, RCW 26.50.070. The respondent will be served notice of his or her opportunity to be heard at the scheduled hearing. You didn't give me one of these. No. No. No, you thought you'd just issue court orders, have me arrested for fake crimes, and then you'd hold me. Oh, well, let's just look at it. Restraint from harassing, following, keeping under physical, electronic restraint. I think I should have got one of these. Now, you didn't need to do this. Yeah, a no contact order on the next page. Terms of order shall be effective until the end of the hearing noted above. Yes. Is that within 14 days, or did you help yourself to as much fucking time as you want? I guess the RCWs of the state are not enforceable, as are the requirements of the VAWA. The respondent's right to due process isn't protected. Yes, you can lose your firearms just for being arrested. Now, warning to the respondent, violation provisions, the violation of conduct, and so on and so forth. Looks similar to what is on the permanent protection order? Yes. You can be arrested. Oh, you can be arrested. Oh, you can be arrested. Then the WACIC. Oh, could you go through the WACIC and find out all the different variations of all the known protection orders? Yes. And then get me all the extreme risk protection orders? Yes. I'm sure that they have a special acronym for them. Now, the clerk of the court shall also follow judicial day, police department. So, did you want somebody else that's not an actual party to this to serve me that didn't have any legal dated time judge commissioner, right? And then there is a signature for the petitioner. Yes. Did she sign this temporary? Well, you she didn't sign it. No. Well, what's this? Oh, look at the order for protection, what I got. Yes. Where you put Superior on top of it. Yes. Then you put the state court seal on top of that as Exhibit A. Ouch! Are you sure it doesn't go on the right side? Because usually they have this way of doing things in court where the Um, Respondent did not receive actual notice of the hearing. Respondent was not present at the hearing. The order is issued in violation of the full faith and credit provisions. Now, for every state of the United States, there's 24 pages to this packet. Yes, looks like you fill out the petition with the same information. Now, this has a place for the petitioner to sign, and she didn't. Oh, I acknowledge receipt of a copy. Well, you didn't give me notice of court hearings. Now, this is the denial of the order for the court. Yes. Now, you give me one time a year to motion the court, and of course you're going to tell me no because I didn't have a mental health having come for hearing upon the request of the petitioner or see, this was a problem when I looked at this denial of the domestic violence, anti-harassment, vulnerable adult sexual assault, stalking, other, and then the extreme risk protection order. It's not on there. Yes. Well, bringing this matter before the court when you issued this in 2011 and I wasn't given any notice. Having come for a temporary order, modification of order, full order, termination order, renewal order. Yes. You didn't ever deny her anything. So now, having come on for hearing upon the request of well, would it be the respondent for a temporary order, modification, termination of the order? So it would be the petitioner that wants to be denied. Well, it says here, court finding, petitioner responded did not appear. Pooch. Now, if she doesn't appear for the court order, the extreme risk protection order says that it be dismissed, and I thought it said the same thing for protection orders, and she didn't acknowledge it, and you used a forgery to issue it. Now, petitioner requested dismissal of the petition. If she doesn't acknowledge the court order, how does she have jurisdiction to motion the court? And when you don't give me notice of court hearing, how do I have jurisdiction to motion the court? In fact, how can you deny a court order where neither the petitioner nor the respondent is given any due process? Now, how can you deny a court order? The court took it upon themselves to issue a court order where neither the respondent nor the petitioner acknowledged its actual existence. But you arrested me, then you arrested me again, Pooch, and then you arrested me again. Now, the petitioner can't request for dismissal, and I can't request respondent. The order submitted has not been completed or certified under the penalty of perjury. Now, if she didn't sign the actual protection order that was served on me, and under the penalty of perjury, she didn't sign the other forms that have the penalty of perjury, do you have the penalty of perjury without her signature acknowledging the court order? I don't think there was any penalty of perjury when you issued it because she didn't acknowledge it being issued. Well, let's say you did sign under the penalty of perjury, but you didn't acknowledge the issuance of the court order under the penalty of perjury. Did she actually motion the fucking court?